Recording in progress.
It's about 10 o'clock. Am I right in Kululeko? My watch is 9:59 still. Is it 10 in Kululeko?
It's 9:59, Chairperson. Good morning,
All right,
Chair.
we'll have to wait. You don't want to look at my ugly face, so I'll come back to you. Here it is 10 o'clock according to my watch now and my computer. Is it 10?
Chair, it's 10.
Okay, let's get going. Welcome, everybody. It's been such a long time in Kululeko that I've forgotten how to chair, so you'll guide me if I get it wrong, okay? Welcome to everybody, including Dennis Ryder and the opposition parties. We have, as all of you know, a very limited year this year because of the elections, and we have to meet our obligations in terms of bills, the budget, and whatever else we have to complete before the end of this term by the deadlines, which I think all of you have now. If I remember correctly, in Kululeko, the NCOP rises around the 3rd of May. Is that correct? Am I right? 3rd of May?
Yes, Chair, you are right.
And then the NA rises around the 26th of March. Is that correct?
That's correct, Chair.
Right. So we have before us a major bill. It's a Section 76 bill. And I'll come back to this issue later. It's about the Western Cape legislature speaker seeking through Mr. Masondo's office, the NCOP chairperson, an extension of time for processing of this bill. And strangely, I also got a letter, which I'm not sure, frankly, it's appropriate for an MEC from a province, Western Cape, to write to a chair to seek an extension of time, but maybe it is. I've never experienced that before. I have been in touch with the speaker. I've tried to begin this morning. In principle, of course, we have no problems. You see, we don't need all these lectures about the constitutional provisions, especially from some people who've come to Parliament and the legislatures recently. We know all of it. The thing is that we've agreed in principle to extend the time, and we will send you the correspondence, the exchange of letters, because it's before Mr. Masondo by this afternoon, and Mr. Advocate Frank Jenkins will also look at the draft I've just been doing up till a minute or two ago. But we will send you all the correspondence in the next 48 to 72 hours. So my reply there is, in principle, yes, of course. We've agreed to extend our public hearings by 10 days or so. Is it 10 days or more? The difficulty we have, colleagues, it's not in our hands, and I'm raising it with the Chief Whip and the Chair of the NCOP. You see, if we make changes to this bill, it has to go back to the NCOP, remember, it's a 76 bill. So they will have to reconvene after the 26th of April. The program that I offered Mr. Mitchell yesterday, in which he seemed to agree, and I think Frank also agreed, then we looked at it carefully and realized that we will have voted on this bill in terms of the amended program yesterday after the 26th of March, which means if we make the changes that we may have to do, the NA will have to reconvene. So that matter is beyond our control. It's been discussed at the top. I don't think we're the only committee, maybe other committees also with 76 votes who might come up with the same restraint because the NA is rising on the 26th of March. In our case, you'll recall we have to manage all the budget issues as well before we rise. So those things can be addressed next week when we meet next time. But in the meanwhile, we'll send you all the correspondence. So welcome, everybody. Is Dikeledi here?
No, Chairperson. She has tendered an apology.
Right. So we know she's going through stresses. I did tell her there's no need for her to attend unless she really has to, and we wish her well. So are there any apologies apart from Mr. Mashlangu?
Yes, Chair. I've got apologies from Western Cape. They sent an apology. KZN Chairperson will join late. I've got apology from our members as well, Ms. Mahlangu and Ms. Nita. That's
Okay, thank
as
you.
far as, yes, Chair.
Okay, let me also warmly welcome our colleagues and comrades from the legislatures and whoever else is here. And shall we hand over now to Treasury to take us through this bill? Sorry about that. Take us through this bill. And I think 45 minutes to an hour is fine because this is our initial foray. It's just getting to a sense of what the bill's about, broadly speaking. We're not going to go line by line today, obviously. And secondly, this bill has been in the public domain for a while. It's been brewing for years, and it's been in the NA last year. It was adopted in December last year. So the version referred to us, which we currently look at, came to us in December. And even with our current program that we offered you, we met all the deadlines of the 6-week cycle and the gap we normally have between advertising a bill and having public. We met all of that. But look, let's not quibble. We'll make as many concessions as is possible to the Western Cape's request. Okay, over to Treasury, please. Who's leading the team?
I've got MP, Chair.
MP, go right ahead. All of us know MP. For those who don't know her from the provinces, she is a senior legal advisor to National Treasury, and she's been there for about 2,500 years, I think. Is that right? Okay, let's go. As have I, by the way.
Good morning, Chairperson. Not that long, since 2012. My
well,
colleague,
metaphorically, you and I are dinosaurs.
Mr. William Matabula, who is the Chief Director in the Chief Procurement Office, will lead the presentation.
Yeah.
Thank you. Welcome.
Thank you, and good morning, Chair, and also good morning to honorable members, and then happy 2024, Chair. I'll be taking the committee through the bill. Of course, with me here is the advocate, Chair, as you correctly indicated, which is here, and then also my other colleagues from the Treasury have joined as part of this session. So I'll be taking you through the bill as the Chair correctly pointed out. Now, Chair, as indicated, Chair, this bill was introduced in the National Assembly on, the screen is just not moving. Moved. Sorry, Chair, we're just trying to make sure that at least the screen moves. I've already moved.
You know what? Inkululeko will help you. It depends who's in control. I'm not sure it's who's controlling it. Is it you, Inkululeko, or is it the department?
It's them on their side, Chairperson.
All right. But you know what, my friend, Mr. Matabula, you know what? We have the thing on our computers. It's been sent out to everybody. So if there is a glitch, you can fix it on your side, but let's not hold the meeting up. From 45 minutes to an hour maximum. Thank you.
Thank you very much. Chair,
but do try to put it back on the screen in case, my friend, in case there is somebody in this meeting who doesn't have it, if you can try to get your colleagues to put it on, the technical people, or in Kululeko, can you take over on your side?
We'll do so, Chair.
All right, let Inkululeko, our wonderful secretary, handle it. He'll manage it on our side. Thank you very much. Right, go ahead, please.
Thank you, Chair. The Chair is correct to say the bill was tabled in the National Assembly in June last year, and then it went through the NA processes, the SCOF process. If you can just put it on a presentation, yes. Then it went through this process, but the aim today is just to present the principles to which the bill prescribes broadly, and also the aspects that are regulated in detail in the bill, and also a range of other aspects that will be prescribed through ministerial regulations within the framework in the bill. And of course, Chair, the government procurement policy is to leverage public procurement to promote those broad socio-economic objectives of government. You can just move to the next slide. Then the aim of the bill, Chair, is to regulate public procurement and to prescribe a framework within which preferential procurement must be implemented. And of course, Section 195, just by way of background, Section 195 requires that national legislation must, among other things, ensure the promotion in the public administration of the following principles: a high standard of professional ethics, efficient economic and effective use of resources, and development-oriented accountability and transparency. Now, Section 216 of the Constitution, of course, stipulates that national legislation must, of course, prescribe measures to ensure both transparency and expenditure control, and also the uniform treasury norms and standards. Then the famous Section, Chair, 2171 of the Constitution, of course, brings about those 5 pillars, which is a system of procurement that is fair, equitable, transparent, competitive, and cost-effective. I think this is just by way of background to this bill, Chair. Nkule can just move to the next slide. Yeah, and then, Chair, the subsection 2 of Section 217 allows for organs of state to implement their procurement policy, providing for 2 things, Chair. One, the allocation, providing for categories of preferences in the allocation of contracts. That's the first one. That is A of 2172. B, it also refers to the protection or advancement of persons disadvantaged by unfair discrimination. Then 2173 requires a national legislation to prescribe the framework within which the procurement policy envisaged in 2171 and 2 must be implemented. Now, currently, Chair, why it's important for us to come up with this bill? Currently, procurement regime in South Africa is currently fragmented, and there are several laws which regulate procurement across the public administration. And this fragmentation, of course, results in confusion as different procurement rules apply to different organs of state. Some of these laws, of course, predate the constitutional order brought about in 1994. And of course, Chair, it's important, considering the history of South Africa and the developments after the Constitution, to have the legislation that creates a single framework regulating the procurement in line with the applicable stipulations of the Constitution, and that effectively addresses the socio-economic challenges of South Africa. And we can just move to the next one. I'll try to be as fast, Chair, as possible. Then this particular slide, Chair, it just outlines the layout of the bill, or the chapters and the themes in the bill. So the bill has got 7 chapters all in all. As you can see, the chapter 1 is just definitions, objects, and application and administration. And chapter 2 deals with the Public Procurement Office, the provincial treasuries and procuring institutions. Chapter 3 deals with the procurement integrity and debarment. Chapter 4 is the preferential procurement chapter. And chapter 5, the general procurement requirements. And we'll go into the details as we run through the chapters. And then chapter 6 is a dispute resolution mechanism, which one may call alternative. And then chapter 7, these are general provisions. So that's how the bill is laid out. Then on this slide, Chair, we just put in the key definitions that the committee should be aware of, and in that order, which are contained. But of course, this is not the complete list of the key definitions in chapter 1 of this bill. But we just lifted up those because we believe they're quite important throughout the bill. I'm not even going to read all of them. Chair, Kule can just move to the next one. Then, Chair, the objects of the bill are contained in clause 2 of the bill. One, the bill introduces uniform norms, treasury norms and standards for all procuring institutions within which to implement their procurement systems as envisaged in section 2171, read together with 2161 of the Constitution. That's the first part. The second part, of course, to determine a preferential procurement framework for all procuring institutions within which to implement their procurement policies as envisaged in section 2172 and 3 of the Constitution. Now these objects, of course, among others, ensure efficient, effective, and economic use of public resources, the advancement of ethical conduct and combating of corruption through access to procurement information and other transparency measures, and introducing enforcement appropriate sanctions for transgressors. It also advances transformation, beneficiation, and industrialization. I mean, those provisions are there. We'll talk about them when we get there. And also stimulate economic development and improve efficiency and effectiveness in procurement by streamlining the procurement processes. And of course, the expedited dispute resolution mechanism. I mean, that's what we're speaking about in chapter 6. And of course, the promotion of innovation and sustainable development. You can just move and go to the next slide. And then chapter 1, of course, in terms of application, clause 3 provides that the Act applies across to departments, constitutional institutions, public entities, municipalities and municipal entities. And of course, in chapter 4, a provision is also made for that chapter to apply to Parliament and provincial legislatures. So that's the application of the bill. You can move to the next one. Then this is chapter 2, Chair. Chapter 2 deals with the establishment of a public procurement office within National Treasury, and then provides for its functions as well, which includes the list below, issuing of instructions and promoting compliance by procuring institutions, and then also taking measures to maintain the integrity of the procurement system, guiding and supporting officials and procuring institutions to ensure compliance, and of course the use of technology and innovation towards a modernization of the public procurement system, and also the measures are, to ensure transparency in procurement and also guidelines. And also this chapter also, provides functions for and roles for provincial treasuries. And of course, the accounting officers and authorities must also make decisions on behalf of procuring institutions in terms of this act. And the duties are also outlined in clause 8 thereof. You can move to the next slide. Then chapter 3, Chair, deals with the procurement integrity. And I think this is quite important. It has been raised over and over again. And the provision here is made for codes of conduct for officials, for bidders, for suppliers, members of the tribunal, and other persons involved in a procurement process, and specific conduct measures, and also due diligence and declaration of interest regarding persons involved in procurement, also prohibiting undue influence and interference in procurement processes, and also provides for automatic exclusion of specified persons from submitting tenders or bids, e.g. POBs, employees of the state, of course, are automatically excluded from submitting. And that is contained in clause 13. And then, of course, measures for functionaries in procurement on how to deal with directions which are inconsistent with this act. And it also provides for a debarment of bidders and suppliers who are found wanting a chairperson. That's chapter 3. You can move Nkululeko to the next chapter. Now, chapter 4 is a preferential procurement chapter, and I must say, Chair, that in this particular chapter, in fact, is informed or finds its expression from section 2172 of the Constitution. So it's important that we had a chapter in this bill dealing with that part of the Constitution. Now, the first iteration of that framework, which is of course envisaged in section 2173 of the Constitution, was the Preferential Procurement Policy Framework Act, and of course its regulations. This act came into effect in 2000, and of course the regulations thereof followed in 2001. Now, the triple PFA, as is commonly known, has certain limitations, and I think a wide range of South Africans over the years have always been complaining that this particular piece of legislation does not go far enough to address issues of transformation in particular. And I think, Chair, I indicated earlier on that section 2172 has got two elements. The first one is the preferences in the allocation of government contracts. And the second part is the protection and advancement, of course, of persons or categories of persons. Now if you look at the triple PFA in its current form, because this is still the part of the legislation that is still in existence and widely used, of course, by all organs of state. Now, of course, despite this limitation, in the sense that this legislation focused mainly on the preferences in the allocation of contract, but not the protection or advancement of persons or categories of persons, as outlined in provided for in subsection B of 2172. Now, but despite this limitation, there was a clear line of sight to the Constitution in that the specific goals mentioned in the triple PFA clearly referenced preference for persons or categories of persons disadvantaged by unfair discrimination on the basis of race, gender, and disability. And empowerment was also measurable, or is also measurable, and the premium also quantifiable. But of course, as indicated, the act itself diluted the impact of preference by combining, at some point, the functionality score with the score for price and empowerment. Of course, there was a case in KZN where the court said functionality or capability, if one were to use them, should be separated from price, from the score for price, should be taken out, and also preferences. And therefore, right now, what is happening, functionality is always the first phase in the evaluation process, where you check whether a particular bidder has got the necessary capacity and capability to undertake projects. And once you've done that kind of assessment evaluation, then you move to the price and preferences as provided for in the triple PFA. Now, that was the first part of the iteration of the framework. Then the second iteration, Chair, of the framework, this was through the regulations of 2011. The triple PFA was left as is, but the regulations of 2001 were then amended through the regulations of 2011. And reason being that when an assessment was done, especially regarding industrial procurement or industrialization, there was, of course, a recognition that since a number of state institutions, especially your big public entities, have got large capital budgets, and therefore the state had to leverage on those budgets. Now, the 2011 regulations therefore introduced the designations for local production and content. So in other words, it brought in the industrial policy element into this act. That's the first part that the 2011 brought about. The second part was, of course, the alignment with the BBBE Act, the status level of contributor, based on cabinet decision at the time. So the two elements, found expression in the 2011 regulations. One, industrialization, because it was key for job creation in the country, and also to ensure that we can't simply import everything into the country, because by doing so, you are somehow exporting jobs in the country. That's what was introduced. And then you can move to, and then it is also submitted that these provisions were outside the scope of the law, but they were never challenged at the time. I think everybody was excited because at least it was an improvement in terms of making sure that industrialization and industrial policy was also implemented through the 2011 regulations. You can move to the next slide. Then, Chair, the third iteration of the regulations were gazetted in 2017. And I think I must say that the introduction of the B elements in the 2011 regulations somehow diluted the objectives of the PPPFA and also undermined the advancement of specific preferential goals, such as Black persons, women, and persons with disabilities. Now, to this end, Chair, the regulations had the following implementations. The advantage was that there was greater and more meaningful measures for empowerment. In the sense, before you move, you can just go back. I don't know, you've moved now to the slide number 1. Yeah, that's right. It's you can just move to the next slide, the next slide. Yeah. The advantage was that there was greater and more meaningful measures for empowerment, as acknowledged by both the minority and the majority judgments of the Concord when the 2017 were declared, of course, by court to be inconsistent with the PPPFA. Now, the 2017 regulations, of course, provided for creation of a procurement policy that is flexible but standardized. Now, the challenge, which was also raised by court, is that it was not the minister's place to determine policy on behalf of the institution, because, of course, the manner in which the PPPFA, had been drafted, it granted the powers to determine procurement policies to organs of state. So that is why then the court said no, but probably the minister did not have powers to do so, and hence then the court ruled that these 2017 regulations are inconsistent with the act. I think the rest is history, Chair. Everybody knows in the country what happened to those regulations. Then, of course, by direction of the court, there was a fourth iteration of the regulations in 2022. So you can clearly see, Chair, that we couldn't, for the longest time from 2001, we couldn't amend the PPPFA, although we've made that promise to South Africans when they say, but that piece of legislation does not go, far enough to address transformation. But we've always been tweaking the regulations, but the 2022, of course, are aligned with the decision of the court. And these regulations took effect, of course, last year in January, and they are in full force. And of course, this process is some sort of a placeholder pending the finalization of this bill. Thank you, Chair. We can just move to the next slide. Right. Now, Chair, we just want also to give the context within the broader Public Procurement Bill of Chapter 4. And the preferential procurement framework should be understood within the context of the procurement system envisaged in Section 2171 of the Constitution. Chapter 4 is also linked to Chapter 5, and the two chapters are linked, which provides for the framework for the procurement system to be prescribed by regulation, within which procuring institutions must implement their policies. It is within this context that there's a trade-off between the competing objectives and principles that is maximized and balanced. And from the lessons learned, Chair, it became apparent that there's a need for a preferential procurement policy framework that is responsive and enabling to deliver on Section 272 and 3 of the Constitution, and of course on other horizontal policy objectives of government, such as a mechanism to give effect to set-asides for women, as an example, and the development, of course, of industry master plans, with the industrialization part, which may lead to designation of sectors for local production where possible. You can then move to the next slide, Ngulego. I'm trying to catch up with the chairs. And Chair, through the...
You know what? Hang on. You see,
Yes.
we normally give you 45 minutes to an hour, right? And
Yes.
especially because
Yeah.
we have very many more public representatives here than we normally
Yes.
do. But you mustn't
Yes.
feel under huge pressure. It's about emphasizing certain things and letting other things pass. So you can have an hour. You're only halfway through that. So don't feel under undue pressure, because some of the issues you're raising deal with court decisions. And I might as well suggest now that we will require an overview of all the court decisions that are pertinent to the bill before us, because we're not lawyers. We can't go through all of that. We'll get our lawyer, Advocate Jenkins, to look at it. But please, that'll be one of the things we will ask. But for now, I think you're doing fine. I think you can finish in an hour. Okay. Because you also want to hear what others say at this early stage. You are now from the provinces. Remember, it's a new coterie of people that are before you now, as against those who were there, well, mostly who were in the NA process. Thank you.
Thank you very much, Chair. Thanks for that. Now, Chair, in our interaction with the stakeholders and the public, right, and also from written submissions to the Standing Committee on Finance last year, there were a number of views which were raised, and of course, some of them which propagated negatively regarding the preferential procurement, despite the fact that the preferential procurement comes directly from the Constitution. Now it is important, Chair, to appreciate that the preferential procurement is not by any means an attempt to drive reverse discrimination against established and white-owned business and large enterprises. That's not the intention of what this preferential procurement. And also, there was also a view that if we introduce this, there wouldn't be, adequate competition in the procurement system. And we're saying that's not the case. And some other views were saying, but with this preferential procurement, the state is going to pay higher prices. And that's not what this is currently happening. I mean, if you look at, Chair, if I might just divert a bit, in the current system where you have the 80-20 and the 90-10 preferences. So the 90-10, the maximum premium payable in that 90-10 preference point system is 11.1%. So that's a premium that the state is prepared to pay to advance transformation. And then in terms of the 80-20, of course, it's 25%. But as you know, that there are thresholds. I mean, above 50 million, then you apply the 90-10, and therefore the 11.1% premium is payable by the state. And then below the 50 million, if tenders are below 50 million, then you've got the 80-20, and that premium is a maximum 25. And then also there was a view that there will be poor quality or low, work and standard, and also corruption. We say this thing is going to promote corruption and illegal policy. And the chair, I think we can always debate and say, how do we view this thing? And then now what we're saying, the bill in chapter 4 seeks to address the fundamental constitutional provisions in section 217(2) and 3 of the Constitution, and provides for regulations to address negotiations with bidders. So in other words, there will be at least an opportunity for regulations which will address negotiations with bidders, which is envisaged to include, among others, the fair market prices, and to prevent government paying exorbitant prices for contracts awarded. I think we just wanted to make this particular point here. I think it must be very clear that the Constitution says we must do it, and that's what we're doing. Now you can move to the next slide. Now, the bill, Chair, that was introduced in Parliament, the chapter 4 of that bill, a number of stakeholders and through public hearings and written submissions had issues that the chapter 4 does not comply with the requirements of the framework as envisaged in 2173 of the Constitution. So now, what we had to do then, we had to go back and check what the provisions of the Constitution as outlined, and then we had to expatiate a little on chapter 4 based on the direction of SCOF at the time. So we went back, and also the comments, written comments, and also the public hearings. So we just want to, at least, run through this particular process. And then you can move. These are just the provisions of the Constitution. I don't need to repeat them, Chair. They are there. What the Constitution says, categories, 2171, a system that's fair, and 2172, there must be preferences in the allocation of contracts, and also the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. And then 2173 talks about the national legislation. So that's this particular framework, this chapter 4, is that framework that will address, and that framework which will replace the current PPPA as we know it. So you can move to the next slide, Kulego. Now, we then undertook the following principles and approaches when we're expatiating on chapter 4, because a number of people, we had to consider what people were saying. The chapter 4 was a little bit short of content, and then so we took those comments into account, and where people were saying this is chapter 4 in that current form was, of course, vague and unintelligible, and did not represent the framework envisaged in section 2173 of the Constitution, and that it was also not clear how bids would be evaluated and awarded. Now, to ensure that the expanded chapter 4 provides a clearer framework for, in terms of section 2173, in that, the preferences in the allocation of contracts and protection and advancement of persons. So these are issues that we took into account when we expatiated on chapter 4. But it does not mean that the elements that we expatiated on were not original, were not there in the original bill that was published, was introduced in Parliament in June last year. From NEDLEC processes, from the FOSAT processes, from Cabinet Committee, from Cabinet, all these issues were there. All we did was just to expatiate, based on the comments that were made by a number of stakeholders. You can move to the next slide, Kulego. Then, Chair, what we then did in expatiating on chapter 4 was also to tap from the previous sets of preferential prescripts, but not in a copy and paste format, rather in a manner that aligned with the aims of subsections 2 and 3 of the Constitution, especially considering the majority judgment in the matter between Agribusiness and the minister, where the court said, of course, there is the quote, that is the red part is a direct quote from the judgment of the court. And then, of course, now these impugned provisions included those relating to pre-qualification for preferential procurement and subcontracting as a condition. I mean, these were contained in the 2017 regulations. Now, in the aforementioned Constitutional Court judgment, Justice Mhlanhla, in particular, stated that the standalone reading of Section 2171, which ignores Section 2172, is not only a disservice to statutory interpretation, but also ignores the founding values of the Constitution. I think this is very important, Chair. So the framework should not only deal with subsection 1 of 2171, but also it must also, address issues that are contained in subsection 2 of 217. Now, this statement confirmed the view that the drafting of national legislation that must provide for a framework to give effect to section 2172 of the Constitution must take into account the founding values of the Constitution and the need to deliberately intentionally redress past discriminatory practices and provide for measures for preference that will make a meaningful difference to the lives of South Africans who have suffered under the yoke of oppression. So you can just move to the next slide, Lego. Then some of the views, Chair, there were multiple views, divergent views in the the written comments that were received. There was another view that the framework should be discretionary and not mandatory, while other stakeholders were of the view that redress is a government imperative and therefore should be applied by all procuring institutions. Now, in response to whether or not it is discretionary for procuring institutions to apply a framework, Parliament, of course, is entitled and required to enact legislation laying down a framework for preferential procurement policy. The question of how tight or loose that framework is going to be and how much discretion it affords to organs of state to develop their own policies, of course, as long as it does not depart from the national policy, is for Parliament to determine. Now, there were other views were expressed that the framework should be centralized from, a whole procurement institutions, where they may implement their preferential procurement policies, while others were of the view that procuring institutions should have flexibility in how they implement the preferential procurement policies. Now, after assessing the various views submitted, of course, a proposal to expatiate on Chapter 4, together with the bill in its entirety, was submitted to SCOF. And after deliberations, the bill was then passed by the National Assembly in December last year, Chair. And I think the report is there. You can just move to the next slide. Now, I'm just now getting into what Chapter 4 provides, Chair, in short. I'm not going to dwell much. So Chapter 4, the clause 16, of course, thereof of the bill, makes it clear that the framework set out in the chapter is giving effect to Section 2172 and 3 of the Constitution. It also makes it mandatory for procuring institutions to implement a preferential procurement in a manner envisaged in the framework. The other thing that it provides is set-asides for preferential procurement. So in other words, setting aside certain category, specific tenders for certain categories of persons. And that's now contained in this bill, in order to advance persons historically disadvantaged by unfair discrimination. And of course, Chair, the point that we're trying to make here is that in as much as we've provided for set-asides, this is not going to be an open-ended kind of setup. The regulations will prescribe the thresholds, because you don't want to say you must set aside openly. So there would be a threshold set and conditions that would be prescribed through regulations, how this is going to apply. The next slide, Gulego. The next slide, Chair, there's a pre-qualification criteria for preferential procurement, and that's contained, of course, in clause 18. And the pre-qualification will apply to procurement with a higher threshold than set-asides. And of course, there's a list of persons to be reached by this clause is broader than the list provided for in the set-aside clause. Now, during the scope process, there was a reference made to a preference point system, but this was replaced later on by the reference to a prescribed criteria. So in other words, the criteria for this particular provision would also be prescribed through regulations. And this particular provision also compels established business to contribute to a transformation and supplier development by recognizing the BBBE level contribution and making provision for subcontracting as well. You can just move to the next slide. Then the next slide deals with subcontracting. So the first was set-asides, pre-qualification subcontracting as a condition of a tender where feasible. Of course, that procuring institutions would have to comply with. And of course, the list of persons to be reached again is aligned with the list similar to clause 18 that deals with pre-qualification. The term feasible, Chair, is used in recognition of the fact that it may not always be possible to subcontract in all tenders due to the nature of some bids. And the provision is made that the persons or categories of persons identified for empowerment must be citizens or owned by citizens of South Africa in accordance with the prescribed percentages. Of course, that would be prescribed. During the deliberations again at SCOF, so the provision was made that the criteria and then the application of subcontracting would be prescribed through regulations, how it would be evaluated and so on. So, but not here, we'll make regulations thereof, which will elaborate much broader than just this principle. You can move to the next slide. This slide, Chair, deals with industrialization. Now, the bill provides for designation of sectors for local production and content. So in other words, to ensure that we don't import everything, but at least in order to build the industrial capacity of the country, or certain sectors, subsectors, products, and of course industries would be designated for local production. Now the power, which I think is important to say, the power to do so in terms of this bill is then conferred upon the minister responsible for trade and industry and competition. But it does not, of course, exclude the Minister of Finance in the sense that whatever designation that the Minister of Trade and Industry would identify, at least there must be a consultation with the Minister of Finance, to make sure, just to look at the impact thereof. Now, unlike the way in which the previous designations were applied, this clause provides for the proposed designations to be gazetted and for the public to be given an opportunity to provide comments. And there's also other conditions like the number of players in the market before a particular sector could be designated for local production and content. In fact, there is a provision which stipulates a minimum of 3 players in the market, at least locally, before that could be considered. But these are just some of the conditions and then the criteria again, Chair, here would be prescribed in the regulations. The next part, and then of course there would be other preference measures that would be provided for, and measures as well to advance sustainable development, and measures, Chair, for beneficiation and innovation. And we know, Chair, that we don't beneficiate adequately in the country. So the bill makes it now possible for beneficiation. We can't all the time export our raw materials and import as finished product, because that, of course, is tantamount to kind of exporting jobs elsewhere. And there's also provision for innovation. I mean, some institutions like CSIR who come up with innovative ideas and so on, when they want to of course, bring these things into government, their innovation and so on, the current regulatory framework somehow does not provide for it. But at least the bill now has got that provision. Innovation, innovative ideas by government, by the private sector, and so on. And also the advancement, the creation of jobs and labor absorption, intensification, and also development of small enterprises within particular geographical areas. So that's what would be prescribed in regulations in detail, and also the contracting conditions. And then the above will be expanded on, Chair, in the regulations, all these measures that we have here. Then we can move, Chair, to the last 3 chapters of the bill. The next slide. This is just the impact. It shows the impact. To say, in as much as apartheid was dismantled years ago, but there is still a need to eradicate its socio-economic legacies and advance policies that build an inclusive economy and promote social unity. And now this framework provides a menu of preferences. I'm talking about that framework in chapter 4, a menu of preferences that must be followed in the prescribed order, and the options of categories that seek to provide preferences in the allocation of contracts, and also in the protection and advancement of persons disadvantaged by unfair discrimination. It goes further than the current PPPFA in that it does not merely provide preferences, the preference point system, but there are other measures, and that will ensure meaningful empowerment, of the previously disadvantaged. Then this chapter, Chair, deals with the general procurement requirements. This is the actual procurement now. Now, the chapter provides for the minister to prescribe a procurement system and methods, and a framework within which procuring institutions must implement the procurement system, which includes a strategic approach to procurement, and also tapping from what other countries are doing in this manner, and also ensuring that there's a strategic approach to infrastructure in the country, infrastructure delivery, the capital assets and goods or services, and also the maintenance of infrastructure and capital assets. Also for disposal and letting of assets, the promotion of innovation, and also the types of procurement methods. This particular chapter provides for a differentiation in terms of the procurement processes, so that you don't have a one-size-fits-all, as a number of public entities and also stakeholders commented, Chair, in their comments. And then it also goes on, the minister may determine by notice the thresholds for different thresholds and categories of procuring institutions, as well as categories of procurement. The next slide. And then it also provides for the use of another organ of state. Currently, Chair, there's always a complaint that when departments and government institutions want to use services of another organ of state, the current regulatory framework does not make provision for it. But at least this bill now does make that provision to say at least organs of state would be able to use services of another organ of state. And then it also provides for measures to prevent abuse of the system, and also investigation of allegations of corruptions, and then cancellation of contracts, and rejecting a recommendation to award and cancellation of contracts in specified circumstances. Now, it also provides for that system, which is a bid committee system, which will be prescribed as well by regulations to cater for different types of procurement. And then the public procurement office, which we spoke to in chapter 2, is to develop the components of an ICT procurement system over time. Chair, but I must hasten to say that this is not equivalent to the IFMS. The procuring institutions must use the components as they become operational. So this is just the use of technology in our procurement systems. This is what this chapter provides, and also measures for access to procurement processes are to be determined in the regulations. It also provides the disclosure of procurement information and its format, where people would want to know the procurement information, and also protect confidential information, including personal information as provided for in that POPIA. The next slide. The next slide, and then the next slide is chapter 6, Chair. Here we are, in terms of this chapter, introducing a tribunal to hear grievances of bidders. Now, there are 3 reasons why the bill introduces a tribunal. Firstly, we know, Chair, that the court processes by their very nature are long. So court processes are long, and this is meant to shorten the turnaround time in terms of the decisions on disputes. 2, it's also costly, not only costly for the state, but it's also costly for bidders themselves, especially SMMEs who may not necessarily have adequate resources to challenge decisions in court. That's all. And then also, it will expedite service delivery because it's kind of a shortened alternative dispute resolution, which is not there in our current regulatory framework. Now, what we're saying, Chair, in terms of this tribunal, we're saying the aggrieved bidders would have to exhaust this internal process prior to, of course, approaching the courts for a judicial review. So this is the process that is outlined in the tribunal. Say the tribunal, of course, there are qualifications of the members to the tribunal, the appointment thereof of the members, and also the tribunal may also review a debarment order, where those that might have defrauded the state were debarred from participating in state processes. And also the tribunal is to be heard by a panel of constituted by the chairperson of the tribunal. And of course, the procuring institution is prohibited from award. So there's a standstill period. So now, whilst the tribunal process is ongoing, the procuring institutions may not award a contract until that process is final. Of course, if any party is still dissatisfied with the order of the tribunal, that party then has a right to approach courts for a recourse in terms of purge. Then the next slide, Kulego. This is the last chapter of the bill, Chair. This, of course, is just general provisions. Here, the provisions made for the Public Procurement Office to investigate any procurement-related matter, but not for criminal purposes, but for compliance reasons, or if there's any non-compliance in the procurement processes, the PPO will investigate, but not criminally, because there are other, state agencies, law enforcement agencies that are entrusted with that particular power. Now, the bill also enables the functionaries to delegate powers and duties. So the ministers mentioned in this bill, have been granted powers to delegate to other officials and within the department. And it also provides for the criminalization among others, of conduct of a person who knowingly gives false or misleading information or evidence, or interferes or exerts undue influence, or even connives or colludes to commit a corrupt, fraudulent, or collusive, or coercive, or obstructive act related to procurement. And it also causes loss of public assets or funds as a result of negligence. But having said so, Chair, the clause 60 of this chapter also provides for a limitation of liability, where officials take decisions in good faith in the performance of their duties. And of course, there is also a provision for exemptions from the provisions of the Act and regulations, as well as departures from instructions. But of course, unlike in the PFMA, where exemptions are open-ended, this particular one, there are certain conditions that are, certain grounds on the basis of which an exemption from this Act, could be granted. Now, the Minister of Finance is to make regulations, as indicated earlier on, regarding all matters specified for regulations elsewhere in the bill, such as the preferential procurement matters, preference system, procurement methods, public-private partnerships, transversal term contracts, and the use of another organ of state for goods and services. I mean, the regulations will outline those kind of issues in detail. And of course, a list of other matters in clause 64. Now, there is also consultation with relevant ministers. I think this is also contained with other relevant ministers whose portfolios might be impacted by this bill. So whether you're talking the development of small businesses, then the minister will ensure that the regulations that are developed around that particular area would have to be consulted with those relevant ministers. So the number of them in the bill. Then the provision is made that different regulations may be made for different categories of procuring institutions and different categories of procurement, an issue that I mentioned in chapter 5, because some of the institutions are saying, no, but we are an energy entity, therefore we can't be treated the same as rail or road sector or even the ICT infrastructure. So there will be regulations dealing with all these sectors. If you're procuring energy, there would be regulations that would be relevant, but part of the bill to energy sector, to the rail sector, to road infrastructure, bulk water infrastructure, etc., etc. These regulations will be made. And then there must also be other regulations on infrastructure and capital assets. And clause 65, also provides for public consultation processes for instructions to be issued by the Public Procurement Office. So in other words, currently the Treasury issues instructions, but the public does not have sight of those instructions. At least now, the instructions to be issued by the PPO would also be put into the public domain so that the public can also have a comment on it. Now, Chair, lastly, a provision is made for amendments to certain and repeal of at least 16 pieces of legislation listed in the schedule to the bill, which includes the repeal of the triple PFA and amendments to the PFMA and MFMA as well. So just to give effect to this bill, and the provisions of the Act may be brought into operation by the President on different dates and allows differentiation regarding categories of procuring institutions. I think, Chair, this is the last slide, and I'm sorry I've taken too long, but this is our presentation to the committee. Thank you very much, Chair.
Mr. Matebula, being far too apologetic, you had a long bill to take us through. You've done it quite competently. Thank you very much. You were barely over an hour because I took the first 5 minutes anyway. Just to remind colleagues, particularly in comrades from the provinces, that you will get a further briefing, obviously, on this bill. So this is only the first briefing. And to members of the NCOP committee, of course, we look more carefully at the bill as we get to the public hearings, okay? So this is what we call an initial attempt to come to terms with the broad principles and major provisions. Although Mr. Matebula took us far further than that. He was very concrete and dealt with very specific things. As regards the constitutional legal issues, I think we can raise general questions, but we will have to get expert advice from within Parliament independently on the constitutional and legal provisions, whether this bill meets those. So those are things that are quite technical, but you can raise general questions. But if it's possible, I think we should look more at the policy issues for now and get more legal opinion independently of Treasury on whether the bill does in fact meet the requirements of the Constitution and legislation. Obviously, the NA did that. So ours is just a sort of review of that. Thank you very much. So let's have the hands up, please. And then Kuleleko will help me to identify people. Where we speak, I think because there are so many of us, particularly for the provinces, our MPLs, I think people should identify themselves and just say which province, which committee. So I see the NCOP members are up, Willie and Fani. There's Honorable Wilson. There's Simon Moletsane. We tend to use first names here, but if any provincial colleague from the legislature is unhappy, I can use surnames. Okay, for now, we have those names. Others will pop up. I don't see any others for now. Please go ahead. And please, colleagues, remember there are others here. There are some 88 of us. I don't know how many of them are entitled to participate at this stage because it's for public reps. There's Madlopa, Queen's iPad, somebody else there. And who else? Okay, in Kuleleko, you'll help me, right? You're better at this than I am. Okay, over to you in the sequence that you identified. Please go ahead, starting with Willie. That was a joke, Willie, that I made earlier in our chat group, okay? No need to respond. Nobody else will understand what I said. Thank you.
Chairperson, if you ever think that I'll be caught on guard by your jokes, no problem. I know you, and it's good to see everybody again. Thank you for the opportunity, Chairperson. Chairperson,
That's
I
a
think...
nice shirt. Our partner will get it for you. Okay, I'll stop being facetious.
My wife buys my clothes. Chairperson, the bottom line is that if you want to bring about speedy transformation, you should run government well and efficiently. So the whole purpose of government must be to provide opportunities for those who cannot provide opportunities for themselves. So just by doing the job effectively, government will achieve their desired outcome. Unfortunately, we saw that that is not the case. If you interfere with the system by firstly implementing cadre deployment and secondly the preferential procurement that is not based on value for money, and it makes government then inefficient and expensive. Therefore, this will only benefit a few cadres and already rich business owners at the expense of people that cannot help themselves. So I think it is very important that we must look at what the final goals are that we want to achieve with this. Now, public procurement accounts for a significant portion of government expenditure. It's nearly R1 trillion, approximately 22% of our GDP. It presents a crucial opportunity for the government to tackle socio-economic challenges by incentivizing companies to engage in behaviors that will contribute positively to our goals. We as a government, or government itself, cannot do things on their own. We must get public-private partnerships. We must get and apply a whole of society approach. And we believe from the DA side that we must get these private companies involved and give them targets that they can implement rather than force down stuff onto them. We therefore, from our side, believe that the broad-based black economic empowerment must be scrapped, and it must be replaced with a sustainable development goal model. The BBBEE policy, which we know, saw is rooted in a concept of trickle-down redress, has proven ineffective in promoting economic inclusion. Currently, it tends to benefit a politically minority, well-connected, already wealthy amount of people. And it's excluding the majority of South Africans who are meant to benefit from it. We are of the opinion that BBBEE must therefore be eliminated, and that there must be an amendment to the preferential procurement policy framework that incorporate a company or companies to contribute towards a range of these sustainable development goals. Under certain circumstances, it can even be that, or let me correct myself, the primary factor must be price and efficiency. It must remain the pivotal role in government procurement decisions. Prioritizing the lowest cost and most effective delivery of the government services will ultimately benefit those who rely on these services and uplift society as a whole. Not as we saw over the last 3 decades, where public services or services to the people got neglected due to a huge amount of contracts that just was not effected or finalized as it should have been. And at the end of the day, it was the people on the ground that suffered due to that. And it was mainly, in a lot of instances, due to people that were appointed to do those jobs, but did not have the capability of doing it. So from the DA side, we believe that the social, that we must, from a, let's call it then, a broad-based society approach must be applied, where companies get incentivized to do certain services to the community, to put back into their communities, instead of being forced down on what must happen with this. We will just carry on creating a richer and richer elite society, and services to the people on ground level will be ineffective. You can go to Bankara or to Kagung in the Northern Cape, where I was this week. You can try and open a tap and see whether there's water running out there. There are taps, because there was a contractor that had to install taps, but there's no water going there. And one of the reasons were that it was a cadre deployed contract that was provided, and the people on ground level still does not have the services. And so we can carry on and give a lot of other examples. Chairperson, that's on a politically level that I wanted to discuss this. I further would like to find out what will be the public participation process in this, and when we will be able to address the provinces on this. I would just like some timelines on that. Thank you, Chairperson.
Can we please try to stick to 4 minutes? On the latter question, I told you we are engaging at the moment. We have to negotiate with the NA. I have been dealing with the speaker. We're not going to do anything obviously stupid. I mean, really. But we're going to go and tell the Constitutional Court, hey, we don't care what you've said. We're obviously going to abide by it. But we are, as I said, I don't know what more I can say, really. I mean, I told you, give me 72 hours. Not me, it's not my call. I've been at it since yesterday. I spent at least four hours on this thing, drafting letters and keep changing them because of the constraints. We're in the hands of the chair of the House and the speaker of the NA. So they're negotiating. I think it's going to take till Friday to finalize it. You will get all the letters. Presumably you've got a copy of the letters. But may I stress one thing? I have been around for thousands of years, and I know often people throw process at you. I'm not saying it applies here because they're opposed to a bill. In this particular case, there are two opposing imperatives. The majority party needs to get this bill through because it's part of its election manifesto, so it'll want to do it as fast as possible. The opposition is opposed to this bill, so they're going to create every stumbling block, right? Maybe even go to court, which is their right, to prevent this happening. To say, hey, look, we stopped this bill, vote for us. That's politics, right? But you know what? I'm a chair of an institution. I'm not here as an ANC person right now. I will take on my ANC hat later when I respond to you, Mr. Alkamp and whoever else. But right now I'm the chair. There are constitutional and legislative prescripts. We're in the good hands of Advocate Frank Jenkins. We're going to consult with him on every little comma and full stop that is drafted from the politician side. So you will get a reply. You're not getting it today. It can't be done. But you can talk to me offline if you want. You can talk to Mr. Mitchell. I've phoned him again this morning, but he's busy. He said he'll bring me back. Okay, let's not come to that topic, please. There's no need because there's nothing more I can do than what I have done. Ask Nkululeko, ask Advocate Frank Jenkins outside this meeting. Right, let's go in your sequence, please. Everybody, you know your sequence for now. The last person was Ms. Queen. Yeah, okay, next.
Thank you, Honorable Chair. Thank you for the presentation. Although it's obvious that we do not, the Freedom Front Plus does not support this bill, I myself, I've got a moral obligation to oppose it because of the contents thereof, the fact that people are being given opportunities on the basis of skin color and not on the basis of qualification. We've seen where BEE has brought South Africa. We've seen what the results of that has been and still is in all government institutions, ESCOM, municipalities on a daily basis. We are currently feeling the effect and actually living the effect, the detrimental effect of this cadre deployment that's taking place. Exorbitant prices that's being paid for services and goods, and you want to further legislate this. Honorable Ocamp ticked most of the boxes that I wanted to speak to, but we will definitely engage of this further. At the end of the day, what South Africa need is quality products installed and services delivered by people that are qualified, irrespective of their race. The presenter referred to apartheid, as we know he would in his presentation, but you do know that you are currently what you are currently doing is reverse apartheid that's taking place. People that are being denied opportunities in the country. The bulk of South Africa and the majority of South Africa that are the ANC supporters that are feeling the brunt of this labor restrictions that you are putting there, although you are advertising it as something that is supposed to benefit them. But it's not the case. It's only a few that feels the benefication of this BEE. And further taking this preferential procurement any further with more strict regulations will definitely just pull South Africa lower into more poverty and more unemployment with more corruption that is going to take place. And it's unfortunate that this government hasn't learned in the past 30 years that enforcing and putting restrictions and legislation like this in place is only detrimental to the country, and making politics about it, like the Honorable Karim said, it forms part of their manifesto. It's just, it's a cheap way of campaigning because people are not benefited with this. Thank you.
Hey, are you
Thank you,
done, Patty? Patty, are you done?
For the moment,
Okay.
yes, thank you, Chair. For the moment, thank you.
Yeah, I didn't say what you said, but I'll come back to it. I said all parties, opposition and the majority party, like in any democracy, we're no different. It's a healthy democracy. Everybody does that, the Labour and Tories in the UK, the Democrats and the Republicans. What's so different about us? Both parties, you're also opposing it for political reasons. So we both on the same page, as it were, from different vantage points. Right, let's move on to the next person. Just a clarity I had to offer, but you can disagree if you like. Who's Wilson?
Good morning.
Yes.
Good morning. Good
Welcome.
morning to you, Honorable Karim. Thank you very much. I am on this line from Limpopo, where I sit in the Limpopo legislature. I am principally covered by the Honorable Okamp and the previous speaker from the Freedom Front. And quite frankly, the simple truth is that our economy can only grow by creating productive synergies between the public and private sector. We know that, and I'm sure, Honorable Karim, you know that as well. However, throughout its tenure, this ANC rule government has implemented a progressively racial divisive procurement framework. And this has clearly resulted in the enrichment of an elite few cadres. It has created the increase of unemployment. We're at our worst poverty levels ever, and inequality is strife. The insistence on continuing with triple BEE policies has failed miserably and facilitated the emergence of tenderpreneurs, enriched systematic corruption, and crowded out economic growth needed to generate jobs and alleviate policy. And I wish, sir, and I will host you with pleasure, that you would come to Limpopo and let me take you around this province and prove to you what the system has done and how this province has collapsed. I thank you, sir.
Thank you, Ms. Wilson. Who's next? It's Mr. Moletsane.
It's Moletsane, Chairperson.
Hello,
Thank you,
Simon.
Chairperson.
Yeah.
Thank you, Chairperson, and good morning to everyone. Please allow me to switch off my video due to
Sure. Yeah.
the
You're already okay.
Thank you, Chairperson. Chairperson, let me first acknowledge the presentation by the Treasury, but I would like to make a comment based on this bill. I want to believe that this country has a national development plan in place, which the intention of it was to build the capacity of the state. And now we find ourselves today discussing actually not discussing about the capacity, how to build the capacity of the state, but we are talking about the sourcing the capacity for the state. Are we not undermining the intentions, especially the good intentions of the NDP, the National Development Plan, which is to build the capacity of the state? I thought maybe the one we'll be discussing this bill, we'll be discussing maybe about to the purpose, maybe addressing how the state can aim to build itself by maybe imposing the instruments that can be used to localize certain goods to inform our economy in South Africa in order to be able to create more jobs. Thank you, Chairperson.
Thank you, Simon. Next, please. Is it Miss Queen? Yeah.
Thank you.
Please go ahead.
Thank you, Chairperson. My name is Madlopa CQ. That is Clever Queen. No, thank you very much, Chair, and the Select Committee on Finance to share with us this important procurement bill. I know that as a province, we made submissions last year on the one that was challenged because the minister was the one that deal with it instead of the relevant people that was supposed to amend or does thing. Chair, I want to appreciate because the challenge that one identified before, I know that the colleagues that have spoken, they always praise this Constitution of the Republic, and we all praise it. But the concern that we had in the previous bill was the fact that Section 217.1 was the only section that was used, neglecting Section 2 of the 271 and 3. But I think on Chapter 4, they are trying to address that one, Chairperson, because the way they dealt with it, it was undermining the preferential policies that was there. I think now, Chair, they have tried to deal with it, but I want to agree with you, Chair, to say, although we see that they have covered a lot of things that was a concern before, but we can't say that legally speaking, it meets the requirement and constitutionally. So one will tend to agree with you to say that we will need really to give it to the legal section to look at it outside the Treasury, so that we are in a position to understand it, because even the one that was rejected by most of the communities, the majority of the communities, it means that legally speaking, no one really look at it closely and deeper, because you could not come up with a bill that will only look at 217 subsection 1 only, when there are other sections below that really deals with accommodation and trying to transform the economy for the majority of the people of South Africa. Chair, we appreciate that you said as legislatures, we are going to really be presented again with this particular procurement. I think we'll be also in a position to ask our own legal section to really zoom at these clauses that has been amended and try to accommodate the submissions that were made before. I want to plead to the colleagues to say that the issue of affirmative action also happened during the apartheid era. So they were affirming the minority group, but now we are talking about the majority group that need to be really involved in an economy. And when you look at it, it's not like apartheid government where people that were not qualifying, not learned, standard 2, were the managers. And then when you were black, even if you qualified, you were not given any position. Here we are talking about the challenges of the past that was made by apartheid government that we are trying to correct, so that everybody become involved in an economy of South Africa. But I wanted to check, Honorable Chair, there is something that was talking about all the sectors, all the sectors that are dealing with procurement. So they are going to be in the same line to accommodate those that were previously disadvantaged when they are dealing with it. I want to check whether is the private sector part of this, because this procurement, I don't think the country is going to really transform the economy if the government alone is the one that is going to be transformed, and then the private sector are doing as they like. You will know, Honorable Chair, that this collusion, the billions of rand, are doing by the business sectors. That is a big corruption that is taking place. But I don't agree with the colleagues when they are saying that there will be corruption and so on, because the big corruption is around the issue of the collusion that is being done by big business, disadvantaging those that were not part of the economy. And now when the government, it's only the government, if you can look at China, you look at France, you will see their procurement policy that there is time that they will identify those that are really at disadvantage and try, but motivate it on that particular matter. But here in South Africa, it's not about motivation. It's a well-known case that the apartheid government was not allowing Black people to be part of the economy, let alone to be part of the business. Even the subjects that they were doing at school, they were prevented to those subjects that will allow them to understand the economy and be part. So this is what we are talking about when we are saying we need to transform and really affirm those that were not part of the economy before. So I think I can say in principle, this bill, it really covers a lot of things that was a concern, but as provinces will look at it closer and then understand it as the presenter was presenting to us. Now we have got a clear understanding what is included, in particular in Chapter 4 as well as Chapter 5, that really outline what has been amended and also what was the outcome of the court. And I want to support the chair to say that maybe all the outcomes of the court in regard to this particular procurement policy bill, it will assist us if it can be given to us when they are coming with this thing of the legal or constitutional, whether this bill does meet those constitutional requirements. Thanks, Chair.
Comrade Madlopa, you can't blame me. On the screen here, it appears as Madlopa Queen. I had no idea it's you. It's very funny to you. You call me Honorable Chairperson, given our relationship in other structures of the movement. All right, not my fault, my friend. That's what you put on your iPad name, okay? So, all right. I'll have to consider that you're now part of the royal family, okay? You're a senior traditional leader, a queen. Right, so let's go on a more serious note. Look, I don't see any hands up, and I think that, look, colleagues, we should be cool about it, as younger people would say. It's our early entry into this area. It's very complex. Nobody's rushing into anything. We have time constraints, yes, but we're negotiating with the NA. And yes, we will obviously have to take the presentation we got here. Treasury will, and those of us who are from the NCOP in our respective provinces will have to go to the provinces and take you through it. So I gave you a bit more time to speak, comrade, because Willie will now say how she exceeded 4 minutes. It's because you're from the provinces, right? And our colleagues from the committee and the NCOP will be looking at this bill very often now. But I want to raise a few questions, firstly to National Treasury, and then some issues that the committee, NCOP committee, might want to think about. Is anybody who wants to speak?
Yes, Chair, I've got Honorable Tolu.
Oh, Tulani, yes, go ahead, please.
Thank you, Chairperson. I'm very sorry, man. I had a gadget problem.
No
so
problem, no problem, my friend. You're right to speak. Go right ahead.
Thank you.
By the way, I got colleagues for about a minute and a half, and I came back again on. Okay, go ahead.
Greetings to honorable members and our chairperson. Chairperson, mine was, I wanted just to find just a clarity from the KZN. I'm the chairperson of finance of KZN. What I wanted just to find out is our committee is commencing with public hearings on the public procurement bill on the 15th of February 2024. And then we wanted just to check the National Treasury officials that when they're presenting the public procurement bill, whether an isiZulu translation of the bill is available, because we wanted to comply effectively with the requirements of Section 118(1)(a). I wanted just to check that one out, Chairperson. Thank you.
Okay, thank you. They'll come back on that. Just very quickly. Firstly, I just want to repeat something so that we're clear and it'll get minuted. National Treasury, you have been dealing with this bill for a very long time. You know all the legal and constitutional objections through the public participation process, through your gazetting of the bill and workshops you would have had. So can you do us a summary of all the court decisions that are relevant, and let us have it within 10 days. I'm sure you got summaries, but even if you don't, you got 10 days to do it. And then it must be sent also to Advocate Frank Jenkins, and we will send it to our secretary, to everybody who's appearing today at the meeting, right? Secondly, I think that, excuse me, you have provided for regulations at various parts of the bill. And this is a matter that has preoccupied us since the early first 5-year term. When some of us felt that what ministers do and departments, director generals and others bring the bills before Parliament is where they feel they can't get their way through Parliament, they insert a clause where the minister will regulate. So we said, no. And it applied to the municipal systems bill. We said these regulations on this part, you have to bring it to the committee for its approval. If the committee does not do it within 3 months of it being tabled in the tabled to the committee, then it's taken as accepted, so that we don't hold up the ministers or the executive and the departments simply because we don't get round to doing it. Others we said, fine, it merely be tabled, it doesn't require approval. Yet others we felt were like silly billy ones. You can't really anticipate inflation rates or something. So you can't ask the minister to come every 2 years to bring any regulations there and so on in certain departments, right? So, there are various forms. So, comrades, colleagues, we have to look carefully at how much of latitude we're giving the minister to regulate and so on. Then I think I should clarify something. It's concretely and specifically not in the election manifesto of the ANC public procurement bill. In fact, as people will know, the manifesto will only be released on the 20th, when is it? I'm not sure the date, I've forgotten. So it's not like, it's specifically in the policy, but it is a general policy of the ANC from 1994, right? So that's the point I was making. And similarly, the opposition parties are doing the same. Understandably, they want to stop this going ahead because they can use it in the election campaign. They're also opposed to it in principle, but that's democracy. They're making a general point. I'm not making a specific point about the ANC's manifesto. If this bill doesn't pass, it doesn't mean the ANC will lose 1% or 2% of its votes. Certainly, I don't believe that. What I want to urge colleagues is, look, the way I see it is we all need to help each other, right? This bill has been passed by the NA, but it is 76 votes, so we have a lot of power also, and it affects the provinces. It's not a 75 vote, so we have to give it earnest attention because it's quite important. But I wonder whether it's going to help. Now, look, this is an initial foray, it's the first time, so a lot of slogans are being exchanged on all sides, okay? Oh, by the way, I see Ambassador Jerry Indo here. We should welcome him. I think he's in Limpopo. I'm not sure what role he's playing at the moment. Maybe he's in the legislature. I should welcome him. But I also noticed the Comrade Dikaledi, the chairperson of our Appropriations Committee in NCOP Mashlangu, she's here. We excused her at the beginning of the meeting, and I did engage with her and say, given all our challenges at the moment, which we wish her well on, family and other, we were fine if she didn't come, but we're very glad to see she's here. And the others who are here, whom I should acknowledge, but I acknowledge all of you anyway. So can I just raise this thing about the minister's powers? We should look at carefully. Advocate Jenkins guide us on that. Now, coming back to the general points we've made on, we're making general points. We're not looking specifically at provisions of the bill, but hopefully we've no choice. We'll have to do it. So here are some things I'd like to raise. You see, I think that all of us need to not polarize this debate. We need to seek the balances that are necessary between the need for empowerment and the need for efficiency. The two are not mutually exclusive. And it's the way departments make decisions and entities make decisions that sometimes bend the stick in the one or the other direction. But we have to find a balance. The facts are glaring. That 30 years later, we have not transformed the economy. 30 years later, those are facts. Go look it up. Look at Stats South Africa as an example, right? The number of Africans in particular, also so-called coloreds, actually. You know, how marginalized they are in the economy. So, you know, just look at the bare stark facts and think about it. If we don't address those issues, we've raised this before in this committee, people's patience is not endless. So what is going to happen is all of us are going to get caught up in the whirlpool of conflict that's going to occur, and it'll be uncontrollable. It's a social explosion that's looming, as I keep saying. So firstly, the balance between price and efficiency. Let's start with the stark empirical facts. Maybe, Treasury, you can come with the stark empirical facts. How about that? DTIC can help you, and you've got it. What is the extent of empowerment? What percentage of the economy includes Black people in general, Africans and so-called coloreds, particularly because of their location in the economy as underdogs, as it were? That's an expression the English use, or marginalized, if you like. Then I think it's far beyond the stage where the state, I think Comrade Madlope said this, you know, believes it can deliver on its own. It's never been the case. That's why we have these compacts. That's why we look for all these structures between the presidency and MECs and premiers and the private sector. I don't think the ANC anymore, the government thinks that it can do it on its own if it ever did. Right now, look at Transnet, look at ESCOM. The private sector is being brought in. And so it should be. The question isn't about whether we should have public-private partnerships. Colleagues, can we think about this? It's the terms of the public-private partnerships. It's around what you have public-private partnerships. For example, basic services that are set out in the Constitution as human rights, as it were, water, electricity, etc. Those things can't be handed over to the private sector, but we can certainly work fruitfully. They can get their profits, we can get our development. We've dealt with this. I think it's true what people say. We might disagree why, to what extent, that triple BEE is benefiting primarily, though not solely, a certain elite, well connected usually to the politicians and other officials in the state. I mean, if you turn to the internet and look at the ANC's documents at its conferences, you'll see that. Turn to the president's speeches. I mean, everybody is acknowledging that. So that's not the issue. But we can't scrap it for the reasons I just set out. Look at the figures. That won't be scrapped. And rather than like trying to sweep the ocean back with a broom, what the opposition parties might want to do is say, okay, we know this is going to go ahead, but let's engage in the concrete provisions of the bill and let's suggest realistic changes, some of which the majority party might agree with, some might not agree with. But if we carry on with general statements on all sides, it's not going to help us to process the bill efficiently. So I'm saying help to improve it, even if you disagree with it. There aren't just race issues. Everybody agrees there's class issues as well. Yeah, you know, Ms. Wilson, you talk about productive synergies. Of course, I think the majority in the ANC, not everybody, and the majority in the government, not everybody, does agree. We need that productive synergy now more than ever. And elites are benefiting. I think we all, in some form, well, most of us in some form or another. I think, Mr. Maletsane, when you talk about localization, that's an important thing. Maybe you want to dwell on that, Treasury. Although by localization, we ultimately mean anybody, white or black, in the generic sense, who has the capacity to produce locally and create jobs. But obviously, the white owners of these entities have to enter into partnerships within the framework of BEE regulations. So I think we are polarizing things, colleagues. It's not going to help us. Initially, I understand the emotional and some people will say moral, but there's moral issues on both sides, may I point out. There are those who will argue they have to oppose this bill morally because it's reverse discrimination. Well, firstly, the Constitution doesn't allow reverse discrimination, and people have gone to court on various occasions. Sometimes they've won and sometimes they haven't. And ultimately, the court will have to be the arbiter, as I think will happen, because many of you will fight your fight here, but if you lose on key issues, you'll go to the court. And NGOs will go to the court who are unhappy. So let that be decided there. But clearly, you know, there are moral issues for empowerment, and some will argue there are moral issues against it. So these are political differences. I'm not sure how much there are moral underpinnings to this, and whose morality anyway. So I think we can throw those words around because we're all politicians, both sides. but it's not going to help us to process the bill. And given the limits we have, and we will look, it's not the amount of weeks we focus on a bill that ultimately matters. It's the number of hours. So you can have a bill spread over 6 months, and the only number of hours you have been on that bill, dwelling on it clause by clause, is maybe 15 hours. But you can finish a bill in 6 to 8 weeks, and you've dealt with the bill for like 80, 90 hours, as has happened in local government on the eve of the 2000 elections. So colleagues, let's not polarize things. I'm pleading, and we the NCOP, we're not the NA, we're much more ideologically and policy driven according to parties. So I'm pleading for that we now move in the next stage to concrete things once we get the public hearings. Having said that, Treasury, there's another issue we need to answer. This bill is quite complex and difficult and challenging. It involves not just Treasury, but other departments, primarily, I suppose, DTIC, but many other departments. Do you have the capacity to implement this? Is there a phased program for implementation? If there is, can we see a program? You see, it's all very well to pass all these words on a paper. Ultimately, the real test is delivery. Can you actually do it? Where's your capacity to do it? Treasury is slowly in huge difficulties, as we know. And do you have the capacity to do it? Now, what about the provinces? Are you going to help the provinces to implement it? Is there the capacity there? So please, Treasury, deal with the questions that are specifically put to you by myself. The others are more for committee members to think about process. If you want to respond to those, fine, but they're really not issues addressed to you. There are issues to the committee to think about. I cannot prescribe to them as a sort of framework within which we process the bill. And we will sit for 25 hours a day if we have to, but we'll finish this bill somehow or the other within the constitutional and legal constraints. Thank you. Treasury, over to you. Are you there?
Yeah.
Yeah.
No, thank you, Chair. Thank you, Chair. We'll just try to respond to some of the comments made, but some of them, as the Chair correctly points out, that they are for the committee, so we'll leave those. Now, the one issue, Chair, that you've raised around around the regulations,
sorry.
the regulations.
Hello. Can I just suggest something? You know what? Some of these questions are quite complex that are put to you. Many of them are general, right? They're political questions. You don't have to respond to them particularly. They're not addressed to you specifically. You're a department official, whatever your personal political identity is. But as far as the specific issues are concerned, you don't have to answer everything here, because where there are long answers, you can give a general reply, and then we will get written replies from you, and we'll be engaging a lot with you, as will the provinces, right? So please don't feel that you have to reply to the political issues, right? That's for the committee MPs.
Thank you, Chair. No, there just is one issue that you raised that we want to respond to, Chair, that pertains to regulations coming to Parliament. Yes, of course, that's provided for in the bill, that the regulations by the Minister would have to go to Parliament for scrutiny. That's the only question that I think is worth answering. The rest of the other questions, of course, Chair, as you correctly point out, will not respond to right here. Thank you so much, Chair.
No, Mr. Batabula, I didn't ask you to exit. I merely told you that there are questions specifically put to you, and you must answer those. There are many, many general political points made. To the extent your bill addresses them, you'll deal with them, but you don't have to deal with the moral issues and all of that. But the other questions to you, there are far too many for you to simply say. There's only one, okay? We also asked you to give us an overview of the Constitutional Court and other court decisions on these issues, etc. So there are plenty of questions for you to answer. I wasn't giving you an exit route. I was merely saying, don't respond it's not a moral issue, because, then they'll say you being a politician, the opposition. I know two of them, they'll say it, right? One has already hinted you use the word apartheid, although apartheid is not only a moral issue. I'm saying to you, you don't have to reply to those questions, but there are sure plenty of questions you have to answer. Go ahead, please. on price and efficiency, on BE benefiting an elite? What are you doing to stop that, etc.?
Yeah, thank you very much. Let me just quickly respond to the issues around, let me use transformation and value for money. These are not mutually exclusive. That's what we've been saying. So both of these issues can always be achieved through simultaneously. And that's an issue. I think we're making a point around the fact that this bill does not necessarily promote exorbitant price as people would want us to believe. No, not at all. So we're looking at those issues of value for money, but at the same time, you couple that to the issues of transformation, because the issues around preferences are a function of the Constitution, so they couldn't be ignored. Hence, we're saying also, Chair, that the regulations that we prescribed by the minister to detail and elaborate on how some of these provisions would be implemented would also be subjected to the public consultation, and of course including Parliament, so that at the end of the day the bill of course reflects the aspirations and wishes of all South Africans. That's what I can say. Now, with regard to the PPP, yes, of course, we do speak to public-private, partnerships in the bill, and that's provided for, and the regulations thereof will also be developed.
Somebody please mute who's disturbing the meeting. If you do want to speak, you can get a chance as soon as the official from Treasury is done, okay? And Kulele, could you just help us to mute the person concerned? Go ahead. Sorry about that, sir.
No problem, Chair. Yeah, and then the issues around the public-private partnerships, those issues are covered provided for in the bill. So the detail will come in the form of regulations, which of course would be subjected to public participation. Now, Chair, on the BBBE, because remember that the BBBE Act itself is actually within the purview of the Minister of Trade and Industry. So as to what should happen to the BBBE, we can always, I'm sure, refer, and as the Chair correctly pointed out, that the extent to which empowerment should be enforced through the BBBE, that's an issue that, of course, we'll raise with the Department of Trade and Industry. I think
Can I ask you a question with due respect to yourself? The committee has a right to ask you, you're part of government as a whole. This falls under DTIC, but it's actually a government-wide program. Treasury itself is required to abide by it. So surely Treasury has a view about the way BBBEE is functioning. For example, have you got any statistics as government? DTIC might have done it. You might be aware of it. If you can get a hold of it, send it to us. Have you got any statistics? I see them every now and then in the media. I don't know who does them, but has the government itself got statistics on how BBBEE has functioned? Not political platitudes, statistics. For example, it's a common sense impression, even amongst ANC comrades, that it's a certain connected elite that keeps getting tenders and empowerment, while the masses are not. Lower middle classes, middle classes don't get it, and if they're not connected, they don't get it. Okay, so surely that's not a new thing. Surely that's been raised repeatedly in your engagements on this bill or other bills. So that's the question. Do you have any statistics in government about exactly who gets connected and I mean who gets who becomes a beneficiary? What percentage of them are doing so repeatedly, etc.? Have you got such statistics? Can you look for it? Can you let us have it?
Yeah. By all means, Chair, we'll look at this, the stats. Of course, we'll interact with our colleagues at the DTI, and then we'll provide the statistics. No problem, Chair.
Okay. Our Secretary will follow up on that and ensure before the public hearings you will get it to us. Well, within 10 days, you'll get those statistics such as they are to us, okay? And our researchers are here and our content advisor is here. So Esther and Poppy, welcome to 2024. Well, welcome to everybody. But, can you please also look for independent statistics on the beneficiaries of BBBEE, not like policy issues, tables and statistics. Who really benefits? Okay, go ahead, sir.
No, we had you loud and clear, Chair. We'll do that. We'll communicate with our colleagues at the DTI straight away and see if we can, and also independently as you're putting it out, because I think there definitely is a tracking system of who benefits and so on. But also we also do have some information from our own system, which is a central supply database. We'll also pull out that information and see if that information will also be helpful to the committee, and the stats and so on will then, of course, mirror that to what the DTI will provide. Yeah, okay.
Yeah,
we
you see,
do
you
have
have
a
the
system.
procurement office. Isn't the procurement office still under Treasury? Kenneth Brown used to be there. I don't know who is. Is that correct? Is he still there?
Yes.
I mean, not he. So you will have statistics from the procurement office. It falls under your portfolio.
Yes.
Good. Okay.
No,
Thank you very much. Thank you.
Hey, can I disturb you once?
No, you can come in. Yes, it's around this issue, is it?
Yes, Chair.
Please
No,
go ahead.
thank you very much, Honorable Chair. Around the issue of the beneficiaries, Chair, maybe it will also empower us as provinces, because like here in the province, we are starting the hearings on the 15th. Maybe if we can get it before that, it will really empower us and also understand who has benefited. Thanks, Chair.
Yes. Does anybody else want to say anything about this? Yeah. No, that's a good point you're making. Is there anybody else who wants to come in on this thing of the statistics, which we're entitled to? They're empirical. We should de-sloganize this thing from all sides. Okay, good. We might find, the ANC might find that there's more empowerment than we think there is. And the opposition might find there's less empowerment than they thought there is. Let's deal with the facts to the extent we can secure them. Thank you. Over to you, Treasury.
I think that's all, Chair, that we could raise. I mean, we've taken the point that some of the questions are political, as you correctly indicated. But I mean, to the extent that the questions that were raised relate to procurement, we'll definitely try to make that information available, as the Chair also indicated. There was another specific case, Chair, that I wanted us to address, because around the capacity of the state, there is a provision in the bill to that effect, that the state should not only be about outsourcing services, but also to ensure that some of the services are, of course, internally facilitated by the state itself, where the state needs to internally offer certain services. It is in the bill. The only thing that we did not do there was to identify which are those items, because obviously that particular issue would always lie with the procuring institution. But at least there is an enabling provision in the preamble of the bill to ensure that the state does create capacity internally. So that's one issue that I thought maybe I should raise. And then with regard to the other issue on whether the bill itself is constitutional, and I think the Chair gave a direction there to say the legal eagles within Parliament, within the committee, would deal with that particular issue. But also, I'm sure from our side, we'll provide the necessary support should it be needed to that effect. That's basically what I'm going to say.
So can I just
Chairperson, I'm sorry.
Yeah. Sorry, who's that?
Chairperson, I'm sorry. It's Honorable Kulu.
Yes, go ahead, my friend.
Yes, I had a question where, because as KZN, as we starting,
Yes, I'm coming to you.
Oh,
you want to?
okay. No, that's
I
fine.
know.
Thank you.
Yeah.
Okay.
Yeah.
Okay.
Mr. Matabula, if you think you're going to come here, with due respect to you, maybe it's your first experience of the NCOP committee, okay? And not answer questions, you're going to delay the process. I mean, Treasury is quite used to us, and MP van Schoor has been with us forever. And you might want to speak to the DG and get some advice, but you're not really helping the process. With the greatest of respect, you presented very, very well, but you evading questions. The only thing that I said to you was not requirement for you to discuss whether the bill is morally sound. You can have your personal opinion on it, but you're not answering the questions really helpfully. We didn't say to you that our own people will have a legal opinion established about this bill, and you will, if necessary. No, it's a specific request to you. Within 10 days, we want, and you must show me why you can't do it. Not me, the parliament. Write back to me from your minister. The minister must write back and tell us as a committee why you can't do it, right? So here we are. There's a province that's meeting on the 15th. By then, give us a summary of an overview, if you like, of all the court decisions that are in some or other way part of the process of your shaping this bill. We have implications for this bill. How did you actually address those concerns? Okay. So there's no if necessary and we'll support. No, we're asking you that. We were very specific. I hope somebody on your side is taking minutes. We want it. And now that KwaZulu-Natal has raised this issue, it has to be done by the 14th, right? So please, can we get that done? You have lawyers there right next to you. On the left of you is somebody who's quite competent and can do it. Secondly, answer Tulani's question. Is there an isiZulu version of it?
I've got Honorable Ocamp as well here.
Yeah, well, can we just deal with these two issues quickly? I'll come to you, Willie. Can you answer the question, sir?
You will. Thanks, Chair. No, we will do, Chair, what you direct us to do.
It's the committee,
we will
not me
get.
personally.
We will get. We will get the court decisions on procurement. We'll get a summary as, of course, the committee directed. We'll do that, Chair. And then the issue around the constitutionality.
Yeah, the summaries will be like an appendix. I mean, the court decisions, which will be lengthy, and we're not lawyers, and we have limited time. And then they brought this bill to us very late, as did you to them in June. This bill has been brewing since I was chairing. When was I chairing? 2014 to 2019, somewhere in that period. You all promised this bill, right? If you look at your programs, I mean, I can ring Alan Wickham and tell you, I think you proposed this bill in that term, okay? So you were held up, whatever reason. Then the National Assembly comes to us in the middle of December when we're breaking, right? So the first opportunity, not even a committee week, we said, no, let's meet today. So you play your part, okay? Now, here it is. You will send us we can get it through our staff. We don't want simply the court decisions. We want a summary of what the key issues are and how they've been dealt with in this bill, okay? And then you can add as an appendix or appendix, all of the court decisions. I don't know who in the parliamentary side, the MP side, will read that. Secondly, Tulani is rightly asking, challenging though it is there an isiZulu version of this?
We don't have any isiZulu version, Chair.
Right. Okay. Then
we
can
don't
I put
have
something?
Okay. Yeah. Any translated.
Yeah. I think
versions of any other language.
Right. Can I plead all the provinces here? You are right to ask for these bills to be translated. And believe you me, it was a big issue between 1994 and about 2004, and it just collapsed. There was a decision taken by Fingy Jinwala and the Secretary of Parliament and the powers that be in the NA that each bill will be put into the major streams, one in Guni language, and then one so-called Northern language, and then either English or Afrikaans. But Afrikaans will not automatically be, even though after 1994, the bills were in English and Afrikaans, and it was an uproar, okay? So at some stage or the other, we were getting bills in about 3 or 4 languages. And then it stopped, and then the chairs asked what is going on in a meeting of chairpersons and the speaker, and the answer we got was that it's hugely, hugely expensive and very time-consuming, especially with long bills. So what we have done, even public hearings, right? We do not have translation, Tolani. What we've been doing is, if somebody wants to speak in isiZulu or Chivenda or any other language, right? Setswana or whatever, we try to find out beforehand through the secretary of the committee, and we'll get it translated. No simultaneous translation, unfortunately. Parliament doesn't have the resources, regrettably. But can we ask, sir, you'll have to ask your DG, could you, in your presentation, your overview, have an isiZulu speaker from the Treasury, right, or yourself, to speak in isiZulu? Now, the fact is that if that's the case, then also the provinces, when they have their public hearings, have to ensure that people in rural areas and so on are involved, because most urban people, not all obviously, and most elites that often turn up at these public hearings, you know, they speak English, but there's no reason why, even if they speak Oxford English, they can't have an isiZulu presentation. So that's what you could do, and that's something your officials can communicate with the officials in KZN. Can we move on from there to Willie? Willie?
Thank you, Chairperson. Thank you, Chair. Chair, I think it's important to get the statistics that you've asked for. And I think if they provide a list of beneficiaries of BEE, that is going to give us an indication of how many people benefited financially out of that. I think that that is only half of what we need as well. I think we should also get a list or statistics about contracts from government side or local government, provincial government, doesn't matter, that were awarded to those BEE or BBBEE entities. How many of those contracts were executed to the letter of the contract? How many of them were not executed well or are still not completed? Or how many of them went over the budget? I think that will give us the big picture of the effects of BBBEE. Not only the amount of people that benefited out of it, but also the effect that it had on service delivery and the implementation of services. And therefore, we need to see how many of those contracts have been completed successfully, which I hope there was quite a lot, but how many of them were not completed successfully or at all, or problems were experienced with that. That will give us a big picture. Thank you, Chairperson.
Any comments on that, Comrade Badlopa?
Thanks, Honorable Chair. No, we really appreciate the presentation and also what has been raised in this meeting about the statistics. But I think, Chair, on the benefits, on the beneficiaries, beside the one that you are looking for, whether the beneficiaries, since this BBBEE started, how they have benefited. Also, we want to make a comparison on the budget, how much goes to those people and the one that goes to the formal businesses, so that we can really look at whether are we making an impact in this transformation and the involvement of the majority of the people of this country. Thank you, Chair.
Yes, that is what we meant, and I think thank you for making it clearer, Willie. I'm not a lawyer. I think this issue has been in the public domain now and then, right? About whether you can look at the contracts and they're confidential and all that. So I don't know whether we're going to be able to get that information. I think between Frank and MP, and they can sort that out. I don't know if we can get it to the detail you want. But what is correct about what you're saying from what I can see, remember, I'm no lawyer. Hey, look, Billy, I'm not a lawyer. So if the law says you can have access, a committee can have access to it, it'll have to be done. But as far as I know, when they look at empowerment, they will have to also look at outcomes, is what you're saying, basically. In other words, okay, so-and-so was given 3 million to deliver such and such. Did he, she, they deliver it? That's what you're asking. That, I think, is a fair question. About having to look at the contracts and all, what are you going to know about contracts? And what am I going to know, really? I don't know. They're very technical things. But if you're entitled to it, let the lawyers on both sides sort it out. Okay. Back to you, sir. Mr. Matebula.
Thank you, Chair. We, as indicated earlier on, we'll get the stats from our own system, Treasury, but we'll also get the stats from the DTI, Chair, on some of these issues. Now, in terms of the speakers who may come in during the presentation to speak on our presentation in isiZulu, we will also attend to that particular issue, so that by the time we go to on the 15th, as indicated here, at least there is an isiZulu interpreter to speak to the bill, I mean, to the presentation as well, Chair. So we'll do that. Then the impact on service delivery, Chair, to be at least it might not necessarily be available, in the shortest, time frame as indicated, but we'll also look at the impact of service delivery, which projects were awarded and whether they failed or they passed the test. We'll also check, but it might not be the state that is readily available within ourselves, because procurement takes place from Cape Town to Messina and vice versa, Chair. We'll have to collate that information. And then we'll also look at the budget issues as raised, because we are responsible. We'll check within Treasury here just to get the budget, how much has gone to certain individuals, including groups of other people that may have benefited out of the BBBE. So these are questions, Chair, that I think are worth responding to. Thank you, Chair.
No, you've covered. I think, thank you very much. And your last thing, I don't think we're going to be onerous really on Treasury. I mean, what we're asking for in the generic sense that's been asked is far too much to ask. It's not reasonable, but within the limits. And also, may I ask Esther and Poppy also, please, look for independent assessments of outcomes of these programs. But, I think within reasonable limits, you can give us some information. Colleagues, the aim today was not so much to go as much into issues as we've turned out to do, which is good. But you know what? The aim was just get a feel for the bill. We'll be getting briefings in the province. We'll be having public hearings shortly, and there'll be further briefings. But I see somebody's got their hand up there. Is it Mendoe, M-E-N-D-O-E?
Yeah.
Please go ahead.
Thank you, Chair, Honorable Chair. Now, I'm partly covered. I wanted to come on this issue of the contracts that were awarded. As we have said, that our system, the centralized supplier database, it does have that information and will be able to communicate that with the committee. But in terms of the execution, how they have been executed, it would be important to, because though the execution happens at the level of the various entities and departments. Then in terms of the, yes, I wanted just to sort of say that information is readily available. Even after this, the system is able to sort of say, here are the contracts that were awarded and here are the people that were awarded. Even the provincial treasuries, they do have that information in terms of the awards. If members would like to get more information, especially if one sees that some of the companies that have been awarded are companies within those jurisdictions. So it should not be a challenge in terms of that. But in terms of the how many were executed, one presumes that if there's been payment, there's been execution. It is on that note that also the provinces will assist in that regard. Thank you, Chair.
Thanks, that's helpful. Who would you be, sorry? You're representing?
I'm at National Treasury. Thank you.
Okay, yeah, I thought so. Welcome. Look, I think you've been very helpful. I don't think really that we requiring every municipality's decision to implement BBBEE. No, a sort of overall sense, and I don't think we want to kill you. You've got many things to do, and Parliament's about to draw to a close. But I think, colleagues, unless there's something terribly new, we covered quite a lot of ground. Let me just draw your attention to what's in the chat group. The South African language bill. Oh, firstly, there's Mr. Jutoy about this article about how BE has benefited state capture and corruption. Well, that's only one of many, many articles, and that's quite a common argument. Frankly, not just in the opposition side, but also if you look at some of the ANC documents and what some of the ANC leaders say, then the South African, yeah, Linda, you're absolutely right. She points out that the language bill of 2012 made it compulsory that each department not compulsory as a provision must translate legislation and state documents into efficient languages. They must budget for it. Yes, I wish you well, Linda. I'm leaving now soon. Your generation must carry that forward. That's exactly what we asked. There's the South African Language Board, what's the one in the Constitution? And then the issue was raised about the Khoisan languages and so on. But that's an issue that is correct. We have the policy, but we don't have the capacity and means to implement. Then there's something else here on the chat group. Let's see, what is it? It's from Willie, I think. For now, they don't have to provide the names of the companies who. I just think that it's important that they provide us with the statistics. Yeah. We agree. It's exactly what I think we're all agreeing with you on. That statistic they'll provide to us. So, colleagues, if there's anything anybody else wants to raise, I don't see any hand up. I want to take this opportunity to thank you, especially those of you here from the provinces, for being here. And to also thank you, Mr. Matebula, and your colleague, the MP, for your contributions. And we will, within 72 hours, well, you see, it seems there's a meeting, excuse me, taking place on Friday about the current dates of the NA Rising and the NCOP. So on Monday next week, I'll be able to, or even sooner in tranches, but you see, I don't make the decisions here, please, okay? I'm cool, right? We can give as much time as possible, no problem. We already have, according to our advocate there, the time we currently have in our current program meets the requirements of 6 weeks. In fact, what the Western Cape's asking for is even more than 6 weeks, which means the cycle in the Constitution provides for 6 weeks. They want an extension of a week. They're the only province who've done that. So we will have to ask for the NCOP chairperson and the Secretary of Parliament to approve of that. And I'm cool if they do, but I don't know, I'm not a lawyer. So we'll come back to the committee in writing by Monday, Tuesday, the latest. But in the meanwhile, I think we'll sort it out by Friday afternoon. If any member of the opposition wants to phone me to find out what's going on, please do. But you will see there's nothing you can do either. You're bound by the same laws and regulations and rules of Parliament, as is the chairperson. Thank you. Thank you once again to everybody. Keep out. Bye.
Yabonga, Chair.
Thank you, Chair. Thank you, Chair.